to repair the carelessness of a party is a matter of sound common sense in the case. Right. Over the above of this observation is the necessity to maintain impartiality, open-mindedness, and fairness. So it was said in the case of S versus Lefranchi, 2009, 9 SACR 125, SCA, paragraph 14. The court must be astute not to take over the role of the prosecutor or to lose its impartiality or the appearance of impartiality. Cases on the subject matter that the section has both a discretionary and a peremptory part. The peremptory requirement, which obliges a court to call for evidence, arises if the witness's evidence appears to the presiding officer to be essential for a just decision of the case. A failure to call for such evidence in these circumstances can amount to an error of law requiring a retrial. I quoted the case of Judge Seriti, you remember, who didn't call a witness, where the facts demanded that he call a witness to regurgitate it. These four guys, they were late, a couple, a white couple, elderly white couple. They were supposedly going to a bank. And when they opened the gate, one of the accused came towards the door of the driver, who was the male, and shot the driver. But the driver, at the meantime, had armed himself with a firearm. He shot back, and he shot this gentleman on the chin. He fell and bled on the grass tarmac on which this car was traveling. The male died, and then the wife survived. The police subsequently arrested all these four gentlemen. But the ballistic expert said that he cannot state as a fact that this firearm is the one that shot the gentleman, the black gentleman who was shot on the chin. Because apparently this was an old firearm. It was rifled inside the barrel. So as a result, the bullet did not have the telltale rifling of the barrel, the inside of the barrel, right? But Mr. Seriti, my brother Seriti, we were together at Forte. What he says, this accused person says, I was at the Shebin, they shot me, ko Shebining. I was at the Shebin. I was never there at the scene of the robbery. And he found it unnecessary. He believed the gentleman, the black gentleman. He found it unnecessary to call for DNA, a DNA expert to come and explain. Because he did what this requirement says in section 186. The peremptory requirement which obliges a court to call for evidence arises if the witness's evidence appears to the presiding officer to be essential for the just decision of the case. A failure to call for such evidence in these circumstances can amount to an error of law requiring a retrial. They quote the case 5R, Director of Public Prosecution, Transvaal versus Mtweni, 2007, 2 SACR 217 SCA. Okay, accordingly then, if this court were to convict, it may be open for the accused to argue that the court was obliged to receive further evidence on the ground that it was essential to the just decision of the case. Technically, the state may claim that the court should have done so since the decision is one of law which renders it subject to challenge on appeal by the state. In cases where it is not essential to call a witness for the just decision of the case, then the court exercises a discretion which places it on risk if it decides to call in circumstances where it failed to exercise its discretion judicial. And then they quote the case of S versus Pinenta, 1989-1, SA WLD, page 896. The difficult position the court finds itself in is well recognized in S versus Ferber, I quoted it, Murray's case. There is obviously potential tension between the need to fulfill the role of a judicial officer as described in Hepworth's case, Supra, and the need to avoid conduct of the kind which leads to the characterization of the judicial officer's behavior in such cases, such as S versus Roll, 1982-1 SA 828A, as irregular and resulting in a failure of justice. Nonetheless, it remains incumbent upon all judicial officers to constantly bear in mind that their bona fide efforts to do justice may be misconstrued by one or other of the parties as undue partisanship, and that difficulty, as it may sometimes be, to find the right balance between undue judicial pacifism and undue judicial intervention. They must strive to do so. In deciding whether to invoke Section 86, the court must scrutinize the reasons for doing so, like I did. In the case, the real reason is not to show up the state's case. Jonathan Hare, in the case of Habau clearly says this: in Section 186, it is essential that the just decision of the case means that the court, upon an assessment of the evidence before it considers that unless it hears a particular witness, it is bound to conclude that justice will not be done in the end. Like in this case, if I don't call these witnesses who allegedly beat up Mr. Kwabeni at the cemetery and even at the gold sport, I will be failing in my duty. So it is essential to the just decision of the case means that the court, upon an assessment of the evidence, before it considers that unless it hears a particular witness, it is bound to conclude that justice will not be done in the end result. That does not mean that a conviction or acquittal, as the case may be, will not follow, but rather that such a conviction or acquittal as will follow will have been arrived at without reliance on available evidence that would probably and not possibly affect the result of the case. And there is no explanation before the court which justifies the failure to call that witness. If the statement of the proposed witness is not unequivocal or non-specific in relation to relate to issues, it is difficult to justify the witness as essential rather than of potential value. It is also been said that the requirement of the testimony to be essential is met if it is the evidence which will disturb the probabilities one way or the other. A court must also ensure that as best as it can, provision of Section 186, even after the ever-present danger of a perception of bias. The three concerns arise in the present case. Okay, so that is the judicial approach I'm using.
ingakho-ke inkantolo ithathe leso sinqumo ukuthi izobabiza labofakazi ngaphambilini kokuthi-ke ingathatha isinqumo kwizethulo ezenziwe ngabameli izolo.
And then the other thing, I said counsel for the opposition for the defense has got the right to cross-examine all these witnesses which the court intends calling. And the accused themselves also have the right to call extra witnesses if it is justifiable to contradict the witnesses I am calling, if it is necessary.
Futhi ke abameli bona ke bazoba nelungelo lokuthi bonke labo fakazi inkantolo seyibashilo abazoza bazokuthula ubufakazi lana ukuthi abameli babahlomeke ngemibuzo nokuthi ninake basolwa ke ukuthi uma nibona noma sikhona isidingo sokuthi ke nibiza abanye ofakazi abazoza bazophikisa lokhu okuzoshiwo ofakazi laba enkantolo ethi iyababiza uma nibona ukuthi sikhona isidingo sokuthi babizeke abazophikisa lokho nalapho ke ninelungelo lokwenza lokho.
Yes, want to say something?
I just wanted to understand one thing.
Yeah.
I do understand the suggestion by the court, but I want to understand where does it leaves us with the application made by the state to cross-examine Gwabeni.
No, it's still there. But I can't.
I mean,
No, it's still there. That evidence is still there. It stands.
I mean in terms of the ruling by the court.
Yeah, no, it
because
stands. It's like I found, for instance, that those 2 or 3 or 4 confessions were admissible. I haven't given you reasons, have I?
yes.
Yeah, same thing. That's why I say I can't rule now without listening to this evidence. Can't.
Okay, I understand.
Okay, and it's not me saying that, it's the law. I say even shonjalo, umthetho shonjalo. And if you think about it, Gininda is a senior policeman. Senior policeman is a general. What is he? A brigadier.
A brigadier.
And then here he goes, and I'm advisedly saying that because it was said by Mr. Gwabeni. He allowed Mr. Gwabeni to be assaulted, even at night. He even allowed Gwabeni to be assaulted when he allegedly was explaining in the office of the prosecutors. He says somebody slapped him. I can't leave that evidence. Decide this case where the truth is. Okay, that's the reason.
So, my lord, when does the court intend to call these witnesses?
Hello?
When does the court intend to call these
No,
witnesses?
Monday.
Monday.
We are here. Monday. You said we must adjourn at about what? 1 o'clock?
11-ish today, my lord.
11-ish, you see.
If it's
What is the time
possible.
now? So we can start with Geninda. If we can start with 2 witnesses, 2 a day. Yeah, fine, no problem. And Mr. Baloyi, please subpoena them. It's not like, you see, it's important that you subpoena them so that this case, if it goes to any other court, they can see the subpoenas. Unlike saying to you, call Brigadier Geninda because he's what is he? An investigating office. No, he must be subpoenaed. He's subpoenaed as a witness. Okay, please.
We'll write out the
Hello?
subpoenas. We'll write out the subpoenas
Yeah, please.
when we adjourn.
Yeah, Mo? Yeah, no problem.
Today's the last day of term. I'm sitting through recess.
Yeah, by the way, it's the last term of the term now. What do you do?
My colleagues have indicated that they are available.
I don't know.
Next week.
I don't want to force people to work during their holidays. You want to work, Mr. Jonas? Otherwise, it's next year. But at least we know what we're going to start doing next year.
Yes, but
If you guys agree, I don't know. If you agree, I don't know.
we'll hear from my colleagues, but they've indicated that they are available next week.
Is it? Yeah, so 100. So next time, when
Next term starts on the
Which date?
19th. I think.
19th.
Yes, of January.
Yeah, we can start next year if you want to. If I'm still alive. Yeah, I mean,
Yes, it's 19 January.
yeah. Remember, Mr. Nisi once said, when we were trying to arrange for the trial,
Inspection in
the
law.
inspection in law crew. Remember, and then Gininda kept on saying, no, you know what, we need to get the police organized, we must get armored cars and blah, blah.
Oh, yes, yeah.
And he said, no, man, why can't we just go out and then have the inspection in local? South Africa is not a banana republic. You remember?
Yes.
Now I can tell him South Africa is a banana republic. They want to kill a judge. They want to kill a sitting judge. You know, even in America, you know how America is violent. They have never killed a judge. In South Africa, the last judge they killed was Justice Cooper. Have you heard about that? You weren't there, you were not
No,
born.
no, no.
1967. I remember because I was still playing for Pirates.
I was already born.
Oh, you're born. Oh, sorry. Yeah, but Justice Cooper, he was handling a case of the Beta gang. There was a gangsters, Beta gang, blah, blah, blah. He was sitting in his sitting room, reading. And somebody came, pumped bullets into him, and he died. And that crime was never solved. They called Scotland Yard, they called the FBI. It was just unfortunate.
Sure.
At least the other guy they killed, but he was an academic, Rick Turner, you remember,
Yes,
in
yes.
Natal. But
Yes.
we know he was killed by so-called apartheid police. But with Justice Cooper, nobody ever found out.
Sure.
One judge in 100 years. This Supreme Court started in 1887 in the old Transvaal Republic. Only one judge has been killed. Maybe I'll join him. Okay.
Yes, my lord.
Yeah.
My lord, I've got instructions from accused number 1,
Yeah.
2, and 3
Okay.
to raise the following, my lord. Firstly, Mr. Kwabeni is still on the stand. He hasn't finalized his testimony. Now, the court has made a ruling that the witnesses that the court has mentioned
No, no,
come
no.
and testify from
No.
Monday.
You didn't read, you didn't hear when I read the law. Interpret the law for them. 186. That's not me saying that.
Yes.
That's a yimi. One among some who found it is a law we inherited from England. Let me use this thing. Yeah. It's a good question you've asked. But this is what the law says. The court may at any stage, the court may at any stage of criminal proceedings examine any person. You want 67,
Yes.
186.
Yes.
That's interpreted. so that
Inkantolo ingathi nangasiphi isikhathi nangasiphi na isikhathi
at any stage may examine any person other than an accused
ukuthi noba umuphi umuntu ngaphandleni wakhe ke umsolwa
who has been subpoenaed to attend such proceedings or who is in attendance of such proceedings.
obiziweke ukuthi ke eze enkantolo noma ke okhona ke nanjengoba icala liqhubeka liqulwa
And may recall and re-examine any person, including an accused.
nokuthi ke inkantolo inako ke ukuthi ingaphinde ibize futhi nokuthi ihlome futhi ngemibuzo noma imuphi umuntu nokufaka phakathi ke umsolwa
already examined in the proceedings.
umuntu ke ebesebiziwe noma ebesekhona enkantolo obesebuthulile ubufakazi.
And the court shall examine or recall and re-examine the person concerned if his evidence appears to be to the court essential for the just decision of the case.
Nokuthi inkantolo isingabiza futhi ke iphinde ihlome futhi ke umuntu loyo ngemibuzo ukuthi noma kuukuthi umuntu obesezile enkantolo yasinkantolo yamdedela ke ukuthi ke useqedile ukuthi ubufakazi bakhe ke uma kuukuthi inkantolo ke ithola ukuthi ke ubufakazi bakhe bumqoka noma ke bubalulekile ukusiza nokulekelela inkantolo ukuthi ifikelele kwisinqumo okuyisona nesifanelekile.
186. The court may at any stage of criminal proceedings subpoena or cause to be subpoenaed any person as a witness at such proceedings.
Beku 167 ke manje u186 ke onaye ke oshoyo futhi ukuthi inkantolo inkantolo ingakwenza ukuthi nangasiphi isikhathi sokuqulwa kwecala ibize umuntu noma ibize futhi umuntu obese kade ekhona enkantolo.
And the court shall so subpoena a witness or so cause a witness to be subpoenaed if the evidence of such a witness appears to the court essential for the just decision of the case.
Uma kuukuthi ke inkantolo ithola ukuthi ke ubufakazi lobo ke ubufakazi ke obusemqoka obubalulekile ukulekelela nokuthi ke inkantolo ifinyelele kwisinqumo okuyisona.
And this section says even after the counsels have closed their case, even if they've closed their case, even after they've argued, the court can still call a witness at any stage.
Lo mthetho ke uthi noma sekusemuva bokuthi ke abameli sebeqedile ukubiza ofakazi babo babizile abasolwa bababiza ofakazi babo ke sebelethe izethulo zabo phambi kwenkantolo inkantolo inako ukuthi ke ingaphinde futhi emuva kwalokho ibize ufakazi.
So the cross examination of Mr. Gwabeni, is it?
Gwabeni, yes.
Yeah,
Senator.
Gwabeni, can continue thereafter because he has made or said or testified to evidence which the court wants to hear
Yes.
from persons who are accused of saying or doing or things. Okay.
Busengaqhubeka ke ubufakazi bakhe ke umnumzana uGwabeni emuva kwaloko ngoba ke umnumzana uGwabeni wethule ubufakazi ngabona ke labantu noma ke kuneyinsolo ayishilo ngalabantu laba ke inkantolo isifuna uza kubona ke emuva kwalokho ke yila ubufakazi bakhe ke sebungaqhubeka khona.
So I take your point, but we can do it at any stage.
Yeah, let me
Inkantolo iyanizwa ukuthi nithini kodwa ke ithi ingakwenza noma yisiphi isikhathi.
now, my lord, raise the second point as
Yeah.
to the procedural cumbersome of that, my lord, because right after those witnesses, then Gwabeni comes in, and then we call, for example, I'm just making an example, another witness that comes and say also, yes, but I also was arrested and
Fine.
assaulted by these police officers.
Yeah.
Then after that, we'll recall the same police officers and repeat the same process.
Yes, everybody must have a say. We are looking for the truth.
Okay.
You can come with a witness from England, and he'll probably say, "Yeah, you know what? I was at that Ngoma, Sugu. I was passing and I saw some dances there, and I looked and I looked and I looked. I don't know. Any witness who knows something, and he wants to contribute to this case, he can do so, as long as it is relevant." Okay.
So, my daughter, I also consulted
Hello?
I also consulted with my clients. There is two issues that I wish to
Yeah, fine.
to understand. Because according to the evidence of Gwabeni, there is two stages of his evidence. It is the stage of the assault
Yeah, fine.
by the said police
Yeah.
officers. So we'll be holding a trial within a trial.
No, we're not holding a trial within a trial. We want to hear your view, your evidence about the fact that Rata says, "You assaulted me."
And the concerns that they are raising, my lord, the alleged assault were not in connection with this case, but they
Which
related to the murder case that we are dealing with here in court. They were relating to the possession of a firearm case.
Which one is that now?
the assaults.
Yeah. They say Mapumulo squeezed the firearm into the bedside.
Yes.
Yeah, it will be put to him. You had a firearm. You planted a firearm on the bedside so that Mr. Gwabeni should be arrested. And indeed he was arrested. We'll hear what he says. I don't know. I don't even know whether Mr. Mapumulo was charged. I mean, Mr. Gwabeni was charged for possession of a firearm. I don't know. Do you know?
No, I don't know.
That's the point. But he was arrested for a firearm, according to him. He says when he was at number 6, sleeping there.
Yes, that's what he says.
That's it. Mapumulo came and planted a firearm, and he told him, I'm not that fool. You can't plant a firearm and arrest me. I remember that evidence.
So the evidence of these witnesses, including Brigadier Kininda, will also encompass the
Yes,
the manner
yes.
in which the statement was obtained.
Even Gwabeni, not Gwabeni, Mr.
Absalom Zongo.
Yeah, Mr. Absalom Zoom, he says, actually in his essence, he says Beninda forged his signature. Or he got somebody to forge his signature. So he must answer to that. I don't know what he's going to say. Maybe he'll say, yes, I told Mapumulo to forge his signature. I don't know what he's going to say. But he must be given a chance because he's a senior policeman who has defeated the ends of justice by forging a signature, according to Mr. Absalom. You heard him. He even said, even me, I'm corrupt. He said that. He's corrupt. But at least I asked him in my defense, do you mean I'm corrupt? And then he apologized. No. You are not that corrupt. I'm not like the guys who are at Matlanga Commission. Okay,
Let us see on Monday.
are we now adjourning and meeting next year?
Well, my lord, as you've indicated, the defense team has intimated that they're available next week. We haven't checked with the rest of the court personnel if
Mr.
they're
Jonas,
available.
you're not available.
I'm still on duty, my lord. Just Monday might be a problem. Just Monday, but I'm still on duty. Just Monday, maybe Tuesday.
Let's adjourn until the 19th.
As the court pleases.
Yeah, because it's going to cause problems.
As
You
the
can see
court
that.
pleases. The other thing is yesterday's argument hasn't been interpreted to the
Yeah,
office.
let him interpret it. He said he would interpret.
Bekufanele ke siqale ngakho lokhu ke bekwenzekile ke izolo. Ngizokhumbula ke izolo ukuthi ke umshushisi kanye nabameli bebenza ke izethulo zabo mayelana naso ke istatement lesi ekukhulunywe ngaso noma ke umshushisi ebesho ukuthi ke kuyisifiso sakhe ke ukuthi ke njalo nje uma ehloma imibuzo kuyena ke uGwabeni ukuthi ke uzoya ke kusona istatement leso usukumileke noma wasukuma ke uadvocate umnisi washo ukuthi cha lokho ke angeke kwenzeke ke ngaleyo ndlela kunendlela thizeni ke ngokwasemthethweni ekufanele umbuso ukuthi uqale ngayo ngaphambi kokuthi nje ungabuza imibuzo kwistatement leso bese ke umshushisi washo ke ukuthi ke lokho kuzoholela ekuthini ke abenze ke izithulo phambi kwenkantolo izothi inkantolo ithathe ke isinqumo sokuthi ke kuzokwenzekani ke izolo ke uma ke bekhuluma ke noma ke umshushisi befunda ke izethulo zakhe ushilo ukuthi ke ummeli wakhe umsolo wokuqala ube nenkinga ke yokuthi kube nemibuzo ehlonywayo kuyena uGwabeni mayelana naso istatement sakhe awasenza ngoba eshoko ukuthi ke istatement leso akukavezwa noma kutshengiswe ukuthi ngempela kuyistatement esenzwa uyena uGwabeni noma senziwa ngaphansi kwaziphi izimo engabe wasayinda yini wakufundelwa yini lokho okulapho okubhaliwe kwisona ke istatement leso uGwabeni ke eqaleni noma ke icala leli uma beqala ke ebekhona noma wayekhona ke kuhla lofakazi bombuso kodwa-ke umbuso-ke wagcina usungambizanga nanjengofakazi. Isizathu-ke ekwanikezwa ngaso lapho ukuthi angabizwa kwashiwo ukuthi yena-ke wakusho noma lokho kushiwo uyena uBrigadier Gininda ukuthi-ke uGwabeni wakusho-ke ukuthi-ke wayesabisela impilo yakhe, yingakho engazanga ukuthi azothula-ke ubufakazi la enkantolo. Kodwa-ke emuva kwalokho umbuso wabusothi-ke kubameli cha-ke nanjengoba lo ufakazi lona sesingasambizi-ke thina sesiyamnikezela kunina-ke ukuthi-ke ningamsebenzisa loyo fakazi-ke. Kodwa-ke ngokuhamba noma-ke ngokufanele naso istatement bekufanele ukuthi-ke abameli noma ummeli nanjengoba kuyena-ke obize uGwabeni kube uyena-ke othi afundeke istatement, asivezeke istatement leso ukuthi-ke ngempela senziwa uyena uGwabeni, wasenza ngaphansi kwaziphi izimo, ngoba-ke nalana-ke umbuso uye futhi-ke wafunda ubufakazi bakhe uBrigadier Gininda kunempendulo-ke anikeza ngayo ethi yebo ikhona istatement Nkosi enkantolo engayithola, anginaso iqiniseko ukuthi labo fakazi labo sebebuthulile yini ubufakazi babo la enkantolo, kodwa-ke sithe ngesikhathi sokuphenya kwethu ngaphambi kokuthi kutholakala istatement sakhe uConstable Zungu zazikhona-ke istatement ezaseyitholakele ezazibahlanganisa noma zibafaka-ke bonke abasolwa-ke kulona icala leli ngokuhlanganyela noma-ke umsolwa ngamunye ukusuka kuyena umsolwa wokuqala kuyofinyelela-ke kumsolwa wesihlanu. Lezo istatement-ke zikhona-ke kulona idokodo. Ngaphandle kwaso istatement sakhe uConstable Zungu. Uma-ke singathi sime-ke lapho-ke kwisona istatement sikaZungu satholakala nini sona-ke kwakuunyaka ondluleke ngesikhathi leso uBrigadier Gininda wayethula ngabo ubufakazi. Uma-ke khumbula kahle unyaka kwakuwuyena u-2023. Uma ngabe bekunikezwa-ke manje ngezizathu zabo noma-ke zokuthi kufundwe sona istatement lesi ngenxa-ke yobufakazi bakhe-ke uBrigadier Gininda ukuthi-ke ubakhona kwakhe uConstable Zungu eBasuthu Hostel nge-22 zika-October 2014. Lokho-ke wakuthola kwistatement sakhe uGwabeni. Ilezo-ke izathu umshushisi ayilethayo-ke phambi kwenkantolo athi yingakho-ke efisa ukuthi-ke aye kusona istatement sikaGwabeni ambuze ngaso, ngoba kwakuyistatement sikaGwabeni esasho ukuthi uConstable Zungu wayekhona laphayana ehostel ngazi 26 zika-October 2014. uConstable Sizwe Zungu naye-ke wethula ubufakazi-ke mayelana nalokho okwenzeka eBasuthu Hostel ngazo i-26 zika-October 2014. Kubufakazi bakhe-ke washo lokho okulandelayo-ke nanjengoba-ke kubonakala kwirekhodi lange-7 zikaSeptember 2023 kuyena-ke upage 4. Uma sesibuka lana-ke uma-ke sesithatha lokhu-ke okushiwo la ngaphambilini-ke kucacileke ukuthi ubufakazi bakhe ukuthi ubufakazi-ke buyasho ukuthi-ke uGwabeni wayekhona-ke kuloko okwenzeka ngazo i-26 zika-October 2014. Kodwa-ke kolunye uhlangothi-ke uma ngabe-ke abameli bona sebesukuma-ke bakhuluma-ke okodwa akukho okuhlukile abakushoyo abameli ukuthi nje thina esikushoyo asishongo ukuthi umshushisi akanalo ilungelo lokuthi-ke angabuza imibuzo ngalesiya statement lesiyana, ngoba-ke thina singabameli sesiqedile, kodwa sikushoyo ukuthi-ke akaveze atshengise la enkantolo ukuthi ngempela lesiya statement kuyistatement ekuyisona, uyistatement ngempela sakhe uGwabeni nokuthi-ke izimo esathathwa ngaphansi kwazo. Yilapho-ke umahluko ukhona phakathi komshushisi kanye nabameli. Lapho-ke manje inkantolo seyiza khona-ke ukuthi-ke ngaphambilini kokuthi ithathe isinqumo-ke sako lokhu okwenziwe izethulo ngako, inkantolo-ke ifisa ukuthi ibize ofakazi laba ebashilo ngamagama ngaphambilini kokuthi-ke izofinyelela kulolu udaba ebekukhulunywa ngalo izolo.
Is that it?
That's correct, ma'am.
Mr. Ramsipidi, there is this witness, Ukwabeni. He came with a note. It's believer. You say you don't know his believer.
Was it me, my lord, that said I don't know Spilivan?
You don't know his believer.
No, it was not me.
Do you know cold drink?
Cold
Where is
drink.
cold drink?
Cold drink, I don't know it, man.
Hello?
I don't know.
You don't know cold drink? Mr. Baloi, do you know cold drink?
My lord, may I approach number one, please?
Yeah, fine. Do you know cold drink?
Cold drink.
Yeah.
Well, it depends the context. Yeah, sometimes.
If Rata is a policeman and comes to you,
Yes,
he stops you because
yes.
you have oversped the speed limit.
Yeah, gratification, yes,
Yeah.
it can mean
and,
a
and then he comes to you
gratification.
and say, hey, manje, if you cold drink. Okay, so this gentleman, he's not here, and he's your witness. You witness, Mr. You witness, yeah. That's, how do we get him to be here on the 19th?
Accused number one, I think that can be arranged.
By whom?
A subpoena can
No,
be,
as long as he's, yeah, I'm just
a subpoena can
I'm
be,
just raising it because he doesn't know that we're congregating on the 19th. Now, who is going to let him know? Should we subpoena him or the defense will subpoena him? Which is which? So how are you going to get Mr. Ngobeni to court on the 23rd?
On the
23rd? Sorry, next month. Is it the 23rd?
19th.
19th, sorry, 19th. That's when we come back on the 19th.
my lord, there's a request from the accused person
Yeah.
that we adjourn until Monday. If Mr. Jonas is not available, another interpreter can
No.
take over.
There are people, administrative things. December, guys write reports, etc., because it's the year end. Don't you write a report, when I'm saying?
Yes, ma'am.
Yeah?
Yes, I do, ma'am.
Yeah. So we can't sit because it's awkward for everybody. So this is our Tibana next year. Okay. In the meantime, you must arrange for Mr. Gwabeni to be there on the 19th next year. Okay. Let's go to the gym.